And we're back. So, just to fill you in on what happened in Madison County, Indiana, in the town of Anderson. I was accosted against my will by a rogue actor, alleged and purported to be a judge, but as all you know, after the Reconstruction Act of 1791, there are no judges. They're all administrators under the executive branch, which means there is no separation of powers, as they purport. And so it warrants and merits what I'm about to do now. And what I'm about to do next is show you guys how you bring a federal claim in a federal court and find resolve. But not only that, I'm going to get into, in a later video, how you can actually invoke the military and report these people to the military to get some judicial action taken care of, because everything is underneath and operating under the DOD, because the Federal Reserve notes are actually military script. All right. This is about liberty, ladies and gentlemen. Make no mistake about it. And it is about the lawful and unlawful means by which government acts in depriving an individual, a man or woman, of his liberty. History teaches us that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. At least this is always the tendency of those who hold executive power. Daniel Webster once stated this problem in these words: "The contest for the ages has been to rescue liberty from the grasp of the executive power. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrest and secret imprisonments has always been an earmark of a despotic executive power. To compound this problem, we have the legislative mills which turn out thousands of new laws every year, which are really statutes, codes, city ordinances, rules and regulations, and provisions. That the passion of the modern legislator to regulate every facet of the most intimate corners of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or a summons, but it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person who he detects breaking one of these laws, statutes, codes, city ordinances, rules and regulations, which only apply to government officials and volunteers. No one can be safe to leave their home or to travel about for fear of being subject to thousands of unknown laws, statutes, codes, city ordinances, rules and regulations, in which he could be instantaneously arrested for transgressing." One law reviewer writes, the problem as follows: people no longer live their whole lives in the village in which they were born. They pass freely from place to place, which is ingress and regress, all right? And in transit go through innumerable towns and villages. The risk of being arrested or accosted against your will on sight because one's conduct contravenes some regulation which the wisdom of the local salon deems necessary is appalling to any thinking person. It would be impossible to know at that moment one might become amendable to arrest, or at one moment one might become amendable to arrest. The revolution in England and the revolution of the American colonies are said by high authorities to have been largely influenced by the promiscuous seizure and search of persons and property. The history of our ancestors over the centuries teach that a people cannot be free where the executive power can arbitrarily arrest or imprison citizens, or ransack at will the properties of the people. The executive power is limited and guided by the law of the land, or due process of law, which I was clearly denied, ladies and gentlemen, as I was accosted against my will for a dubious crime alleged by the judge and prosecutor. They said that I was in violation of contempt of court and that it was criminal when I ascertained and sought the knowledge of who, what, when, where, how, and why, and who was the victim that was aggrieved so I could pay to them or provide remedy. They were silent, meaning there was no victim. There was no affidavits. So the prosecutor alleged that I was speaking but had no firsthand superior knowledge of it and just pointed the finger at the guy in a really nice button-down shirt, and the judge said, "Arrest him." Okay? I wasn't speaking in that courtroom, and I'm willing not only to provide an affidavit and spend 1 year in jail and a $10,000 fine, but I'm also willing to stipulate to a polygraph test to prove that I was not speaking in that court. All right? To add insult to injury, the alleged judge, who's an administrator that I went before today, was the judge, jury, and executioner of his own claim. Is that due process of law? Because here in the United States, if somebody accuses you of something, you go before a non-biased third-party individual set to rule on the matter. You're able to face your accuser and the witnesses thereof. You're able to cross-examine. You're able to do a deposition. I was not purported or allotted any of that today. In fact, today, I just as well have been in China. All right? Nevertheless, I'm out, but only because I'm highly articulate and very learned. And that's what I'm trying to stress to you guys. You have to take heed in what I'm saying and read, because if you don't know your rights, you don't have any. All right? The history of our ancestors over centuries teaches that people cannot be free where the executive power can arbitrarily arrest or imprison citizens or ransack at will the properties of those people. The executive power is limited and guided by the law of the land or due process of law. If it was a restriction upon the King of England, it must be so for every petty officer today. In many of the treaties on the law pertaining to the rights of citizens, and in many of the older and better court cases, we find the declaration, the law is very jealous of the liberty of the citizens. What law is it that so regards liberty? It's the common law, and it declares that one who interferes with another's liberty does so at his own peril. So that's the difference between general liability, ladies and gentlemen, and personal liability. This law also prescribes how arrests are to be made and the restrictions involved. What constitutes false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It's basically involves any unlawful violation of the liberty of another. The ancient English legal scholar Henry Day Bracton, 1200 to 1268, tells us that false imprisonment is one of the oldest violations of rights known to man. Forcefully to deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. False imprisonment is classified as a tort under the common law and also as a crime. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for a remedy. Depriving a person of their liberty is legally no different than depriving a person of their property, because property are rights and rights are property, ladies and gentlemen. A theft of liberty is a wrong by which remedy can be had, just as is the case with the theft of property. False imprisonment is a great offense due to the high regard the law has for liberty. In Chitty Practice of Law, it states, the infraction of a person's liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment or malicious prosecution. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on hands is not necessary to constitute an unlawful detention. Thus, the only essential element of the action are 1, detention or restraint against one's will, and 2, the unlawfulness of such detention or restraint. In his treatise on the law of torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consists in imposing, by force or threats, an unlawful restraint upon a man's freedom of locomotion. Blackstone, in his commentaries on the law, 3 BLM-COM, Black's Commentary, 3 Black's Commentary 127, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison, or in a private house, or in the stocks, or even by forcibly detaining one in a public street. Thus, any type of detainment or confinement of a person, or restriction or deprivation of their liberty or freedom of locomotion, where he is compelled to remain where he does not wish to remain, or to go where he does not wish to go, is an imprisonment. Not only is it an imprisonment, but it's also human trafficking, kidnapping, theft of property being time, okay? Is an imprisonment. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being an unlawful restraint of the liberty of the citizen or of the primary right of freedom of locomotion, the Supreme Court of Idaho also stated, imprisonment is any restraint of the person's liberty of another and preventing of his movement from one place to another, or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. In reviewing several textbooks, definitions on false imprisonment, the Supreme Court of North Carolina stated, false imprisonment is the unlawful and total restraint of the liberty of a person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belongs historically to the class of rights known as simple or primary rights. The theory of the law is that one interferes with the freedom of locomotion of another at his own peril. A rather complete description of what does and does not constitute false imprisonment was given by the Supreme Court of Kansas as follows. False imprisonment is necessarily a wrongful interference with the person's liberty or of an individual. The wrong may be committed by words alone or by acts alone or by both, and by merely operating on the will of the individual or by the personal violence or by both. It is not necessary that the individual be confined within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation, nor is it necessary that the wrongful act be committed with malice or with ill will, or even with the slightest wrongful intention, nor is it necessary that the act be under color of any legal or judicial proceeding. All that is necessary is that the individual be restrained of his liberty without any sufficient legal cause, therefore, and by words or acts with which he fears to disregard. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty or locomotion, it is a false imprisonment. False imprisonment is the name of the category for the torts that unlawful deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definitions of false imprisonment usually come from unlawful restraint of this nature. False imprisonment has been well defined to be a trespass committed by one man against the person of another, by unlawfully arresting him and detaining him without any legal authority. The law sets such as a high value upon the liberty of the citizen that even an attempt to unlawfully arrest is esteemed a great provocation. All the authorities agree that an arrest may be made either with or without any physical force or actually touching by the officer. Thus, any illegal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie, any restraint but put by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual, usually made by an arrest, and physical custody or restraint is not essential to the effectuation of an arrest. So if an officer tells a person that he is under arrest and he thereupon submits himself to the officer, going with him and obeying his orders, such person is deprived of his liberty. And if that act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure, nor any resistance, the intentions of the parties to the transaction are to be considered. In such a case, there must have been intent on the part of one of them to arrest or restrain the other, and intent on the part of such other to submit. Under the belief and impression that submission was necessary, the following definition will provide further insight into the nature and elements of false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used, the word false seems to be synonymous with unlawful. Any exercise of force or expressed or implied threat of force by which in fact the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person without warrant or by an illegal warrant or a warrant illegally executed. Any restraint, however slight, upon another's liberty to come and go as he pleases constitutes an arrest. Length of time requirement. The tort or wrong of false imprisonment occurs the instant that one is restrained in the exercise of the liberty. There is no unreasonable length of time for a restraint before the tort can be claimed. False imprisonment at common law and elsewhere consists in the unlawful detention of the person of another for any time whereby he is deprived of his personal liberty. Where two people are traveling in a car and stopped by police and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment, even though the person was in the police car for less than a minute. It was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. Where one is told to stay in their car by an officer, though it be for only 10 seconds, it is an arrest. Time duration is not a factor in making an arrest. False imprisonment is defined as an act which, directly or indirectly, is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration, makes the actor liable to the other. When one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. Damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. All who do so without lawful authority can be sued for the trespass upon liberty and loss of time. It thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, that person is entitled to receiving a remedy for damages. Not only is a person entitled to receiving a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offense at the common law, and relief by the party aggrieved was obtained by an action for trespass via et armis, with force and arms. The illegal arrest of a person without warrant or under an individual warrant entitles him to compensation for the damages sustained by reason of false or unlawful imprisonment. The general rule of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did. In Murphy versus Countis, Countiss, 1 HARR Del 143. In an action for trespass, assault and battery, and false imprisonment, the court held that the plaintiff could recover not merely for the time the constable was bringing him to jail, but for the whole period of his imprisonment. And in Mandeville versus Gunsry, 51 BARB, New York 99, the court said the arrest being wrongful, the defendant is liable for all the injurious consequences to the plaintiff which resulted directly from the wrongful act. Unlawful interference with or injuries to the liberty of a citizen is a violation of this nature, inherent and absolute rights, which damage results as a legal consequence. A false imprisonment generally includes an assault and battery, and always at least a technical assault. An unlawful arrest, imprisonment, and persecution of a person can cause that person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress or anguish, humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap to some degree, but all can and have been claimed in false imprisonment suits. Upon the subject of damages, the law specifies two kinds of damages are divided them into two classes. There are what are called actual damages, and then there are what are called punitive damages. Actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment, they could include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong, and outrage. These are also called compensatory damages, as they compensate the injured party for the actual injury sustained and no more. Punitive damages are those that grow out of the wantonness or atrocity, or aggravated by the act. They are the injuries and suffering that were intended or occurred though through malice, carelessness, or negligence, amounting to a wrong so reckless and wanton as to be without excuse. These are also called exemplary damages. So what's your innocent explanation as to falsely accosting me against my will, alleging criminal contempt with no victim, no affidavit, and nobody wanting to put their money where their mouth is? Huh, Judge? I'm sure you'll have no problem explaining this in federal court. Anyone who assists or participates in an unlawful arrest or imprisonment, that goes for you, Sheriff, and all your little buddies who don't know the law, who I clearly told you, you might want to start studying what you're doing, because your job is to pay attention to what's going in the court. As an executive branch officer, you have three duties: make an observation, create a record, and report it. And if you didn't make an observation, create a record, and report it, when I report you guys and you didn't do your job, you're in breach of your fiduciary duty and you're going to be in trouble. Anyone who assists or participates in any unlawful arrest or imprisonment is equally liable for the damages caused. Thus, where a man was illegally arrested by a police officer and was placed in a patrol wagon in which he was taken to the central station, it was held that the two officers in charge of the patrol wagon were liable, along with the arresting officers, for false imprisonment. I tried to warn you guys, you didn't listen. Malicious prosecution. In many cases of imprisonment or wrongful arrest, there has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the two charges are not interchangeable or synonymous. There is a fundamental difference between these two charges. They are made up of different elements, enforced by different forms of action, are governed by different rules or pleadings, evidence, and damages, and are subject to different defenses. One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicito for the recovery of damages which have proximately resulted to person, property, or repudiation from a previous unsuccessful civil or criminal proceeding which was prosecuted without probable cause and with malice. In an action of this type, the burden rests upon the plaintiff, the one bringing the suit, to establish each and all of the following propositions before being entitled to recover. To wit, he was prosecuted in a criminal proceeding or a civil suit. 2. Defendant instigated such prosecution. 3. The prosecution terminated favorable to the accused. 4. Defendant acted without probable cause. 5. Defendant acted with malice. And 6. Damages that were caused. In Indiana, a case arose in Indiana. Wouldn't you know that? Holy sheep shit. Guess where I'm at right now? Being unlawfully detained against my will by a rogue agent and agency. I was in Indiana, so let's read on about this case. In Indiana, a case arose where a man sued several officers for unlawfully arresting and imprisoning him in a county jail. Uh-oh, sounds pretty similar. And without any charges preferred against him, the defendant insisted his complaint was bad as it was. His complaint was bad as it did not allege that the imprisonment was malicious and without probable cause. The state Supreme Court rejected the claim. There is a marked discretion between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial without legal process, it is false imprisonment. An arrest or an imprisonment can be malicious or false, but not both. In a case of malicious prosecution, the arrest or detention is procured from malicious motives and without probable cause, but was done under lawful process. Whereas in false imprisonment, the detention is without proper legal authority. One may be legally arrested for some alleged reason. Oh no, my battery's running low. One may be legally arrested for some alleged reason, but not maliciously. If he is found to be not guilty, then has a case for malicious prosecution, but not false imprisonment. If the arrest is not pursuant to legal forms of the law, then whether he is guilty or not, he has a case for false imprisonment, but not malicious prosecution. If this is done with malice, it would add punitive damages to the suit. In describing the distinction between these two charges, the Supreme Court of Oregon stated that foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for any injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest form of law. In other words, the want of authority is an essential element in an action for false imprisonment, whereas malice and want of probable cause are the essential in an action for malicious prosecution. Somewhat different to the other side of. Thank you. Appreciate you. Somewhat different to the wrong of malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose in which malice or ill will may also be a factor. Now, let's just think about this Scott Allen Vorek, Beardek, whatever his name was. You were the judge, jury, and executioner of your own claim. I asked for a different judge in Article 3, Subsection 2, Subpart 1, because the conflict of variance between the rules at law in rem versus the exclusive jurisdiction of equity. And you said, I don't know what you're talking about. Well, far be it from me to explain the law to you, because all men are responsible for knowing the contracts you enter into. I accept your Article 6 oath. I accept your Title 4-101 oath. I accept your Indiana constitutional oath. And I accept your Title 5-333-1 for-profit oath. And anybody in constructive possession of decedent estate property is liable for the transfer taxes on a carryover basis under Title 26, 2603, 2203, 2002, 2001, and you're required under Title 26, 2032, AE 11 to be independently bonded with the Secretary of the Treasury of Puerto Rico. And he just looked at me and goes, you talk really fast. Yeah, because I know what I'm doing, Scooter, and we're about to have a whole lot of fun. All right, a whole lot of fun. The term malice arrest is used in some cases instead of a malicious prosecution, but the latter is broader in scope. The law of the land. The authority to arrest without warrant was rather limited and well defined at common law, a law which has been made part of our constitutional law in the due process provisions. The common law rule on arrest is based on experience and common sense. As a general rule of common law, an arrest could not be made without a warrant. What were they lacking the other day? Could it be a warrant? Oh, by gee golly shucks. And they were lacking any witnesses, and I got 12 witnesses filling out affidavits right now stating what they saw in the court, and the fact that I wasn't talking, I wasn't being disruptive, but sitting quietly taking notes when you decided to take interest in me because your purported attorney, your prosecutor in the room, decided that he thought he heard me say something while he was about 18 feet away from me and his back was turned to me. Somehow he miraculously had eyes in the back of his head and knew that I was communicating. All right. And then you ordered me arrested against my will, absent a victim, absent a crime. And you alleged, you would have been better off alleging that it was a civil contempt of court and that there was somehow a contract that had been bestowed upon me. But no, your dumbass said criminal, and it's on the record. And I'm going to subpoena that record. And if you make that record disappear, well, we've got ways of getting it, because I wasn't the only one in the room and my friends wore cameras. Oh yes, ladies and gentlemen, you never go anywhere around these tyrants without cameras. So this suit is going to be short, it's going to be sweet, and I can't wait to hear his innocent explanation as to how he accosted a man against his will, absent any facts and evidence, just because he felt like it. And then he turned around and decided he was going to be the judge, jury, and executioner of his own claim. So much for not being biased, right? After he had just completed a really nice speech about how he was going to uphold due process of law, and that due process of law is the rule of law in this country, and that he does his best to uphold it. Then he accosts me against my will without a trial. He decides to be the biased judge over his own accusation and finds me guilty before I even sit down. Isn't that amazing? That's due process, ladies and gentlemen, in Madison County, Anderson, Indiana. And I was just bewildered because I was told before I got there, this place is corrupt. And I'm like, I've dealt with corruption. It's everywhere. I ain't never seen it like this, ladies and gentlemen. Let me tell you something. They know they stepped on a landmine, because when I walked out of that courtroom, the deputy sheriff goes, I've never seen anybody talk to him like that doesn't do 30 days in jail for contempt of court for being that way. And I go, yeah, you've never seen a man in here that knows the law. I know the law very well. And they're also going to be liable for it, because after I was ordered to be released, they decided to keep me for extra time because I wouldn't give them my name, my address, my date of birth, or identify. Well, those are medical records, ladies and gentlemen. And I'm protected by HIPAA not to have to disclose any medical records, because what do you think the COLB is? The COLB, the Certificate of Live Birth, is a medical record, and I can't be compelled to produce that absent a crime, absent a victim. So the sheriff comes back down, the deputy sheriff, the, a colonel in the jail, and he comes back down and he said, he was awfully red in the face. And I said, I told you should have let me go. Now you're personally liable. Now you're on the hook. See, before the sheriff said, hey, it wasn't my guys that arrested you. It was the judge. We're just following judge's orders. It was the judge. It wasn't none of my guys. Well, I'm sorry, Scooter. After the judge released me, and then you decided to hold me longer because you wanted to extort information out of me so you wouldn't have to foot the tab of warehousing me overnight, guess what? Now your department became liable, and your agents and agency became liable, and you become liable because those people work underneath you, Sheriff. I told you guys to pull your head out of your ass. I told you I wasn't your average local. I told you that I wasn't going to take this too kindly. You had 3 jobs, Scooter. Make an observation, create a record, and report it, and you were too afraid to stand up against a lying, looting, pandering bar member who is still currently in good standing with the Indiana Bar Association. I looked it up. He's in good standing with the Indiana Bar Association, which means how can he be a non-biased third party when the prosecutor is a bar attorney in good standing, the judge is in, the alleged judge, which is really a ministerial administrator, is in good standing with the Indiana State Bar, still has his oath of office with the Indiana State Bar. Are you starting to follow what I'm laying down here? The man, it's collusion and corruption at its finest. All right. right? The prosecuting attorney points to me and says I'm the one talking when his back was to me the entire time. The judge just agrees with him because they're bar association cronies, all right? And right away I'm cast into jail. And I'm sitting around a dozen people that are all saying, he didn't say anything. A dozen. A dozen far outweighs two. And two that are criminally corrupt and working together to fleece unsuspecting Americans of their hard-earned labor. Oh yeah. Oh yeah. The objective in the law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, where a threat, excuse me, those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for those offenses, summary arrests had to yield to the liberty of the citizens. The liberty of the citizens is too sacred to be left to the arbitrary will of men. So you see, you probably should have just let me walk out of the courtroom. You probably should have just asked me to leave. But no. You wanted to play God, if only for a minute, because you are so used to running amok over the American people, you didn't realize you just stepped on a live wire. That'd be me. Everyone knows what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, and armed robbery, abortion, pedophilia, treason, and arson. A breach of the peace is also obviously and well known. Therefore, everyone's liberty was safe, since all knew for what reason they could or could not be arrested. But there is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact, or if the law on arrest can be changed by statutes. By the Due Process Clause, the common law governs that the law on arrest is in this land, and where it exists, the most statutes is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of the law followed, not a legislative statute or city ordinance. Officers who do not abide by this law are trespassers and are guilty of false imprisonment. I don't care if you wear a black dress and you're a cross-dresser at your daily job. I don't care if you wear a gun and a badge. Y'all better start learning the law, because I'm going to teach all these people how to do this. All right, I'm going to lead by example, because that's what real leaders do. That's what true people that have heart and understand what freedom is and know that freedom isn't free, that's what we fight for every day. So there's going to be a federal case that's drawn from this because of this. The following is some material to help a citizen in protecting his liberty from unlawful encroachment by executive officers. Now, let's go over who's an executive officer. Everybody in Congress falls under the executive branch. Everybody in the judicial falls underneath the executive branch. Everybody in the sheriff's office falls under the executive branch. The question becomes why? Because the Reconstruction Act of 1791, during Abe Lincoln, when he had a memorandum to reconvene Congress, Congress had the authority to reconvene on their own. They chose to reconvene under Abe Lincoln's memorandum, which means they're the board of directors for the commander-in-chief. There's no longer a president. Then what happened is the judiciary sat idly by with their thumbs up their bums and did nothing. So they became the administrative branch under the executive branch for the president, which is really the commander-in-chief. So everything they're administrating in those courtrooms is for the benefit of the commander-in-chief of the largest standing military army ever to exist. All right? That's how that works. That's why there's no separation of powers, okay? So when they're trying to blow smoke up your ass and tell you there's separation of powers, you just remind them they took the Title V 3331 oath, which is for profit, which means they can be sued they can sue and be sued. They're not operating under the Article 6 oath. They're not operating under the Title 4 101 oath to the flag. They're not operating under the state constitution oath. They're operating under Title 5 3331, which is directly tied to Title 28 3002 15A, a federal corporation. All right. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter. And with that said, I'm going to divert you to the topic of this book so you too can go enjoy this book, because I was just unlawfully incarcerated against my will, and you can bet your sweet pumpkin this guy bringing a claim. No more Mr. Nice Guy, but there's the book, all right? And it's written by Charles A. Wiseman, and guess who's going to be submitting this book into the federal court of claims with his claim? This guy, because all this stuff right in here is absolutely factual, all right? And they even go as far to go ahead and show you how to structure your complaint. Now, I make a claim because I'm a man. I'm going to make a claim. They want to make a complaint. I don't make complaints. Men make claims. Corporations make complaints. But here you go. They even give it to you. Letter for letter, exactly how you need to structure it. Send it right to the federal court and get it whacked and stamped. All right? Not that damn hard. Now, you might ask, well, what is that worth? What is a minute of your time worth? How do you value it, Derek? Well, we know that dissimilar things should not be joined and similar is not same, correct? We understand that. And although similar is not same and dissimilar things should not be joined, I can look at Treatise versus the city of Tampa Bay in 1984. It was $1,400 a minute per minute that he was detained unlawfully against his will. Now I take $1,400 a minute and I want current market value today, because the Federal Reserve note has lost 40 or 50% of its buying power since that time, and we go ahead and bring it to current market value, which is something like $5.9 million a day or something. Do I have to go that high? No, I don't. But I want to show the American people that our rights don't diminish in value like Federal Reserve notes or fiat currency does. All right. So if you're going to run around saying, I'm going to bring a claim for $1,400 a minute, know that you have diminished the value of your rights, ladies and gentlemen. All right. I want the same amount of precious metal Mr. Treatise would have been able to ascertain for his 23 minutes of unlawful arrest. Okay. I want the same value in precious metals, because that's what I base my value from current market value, all right? So I find out how much Treatise could have bought in gold in 1984 at the time his award was issued, and I turn around and say, I want that same 79 ounces of gold per 23 minutes, all right? So with that said, love you guys. We'll be talking to you really soon. Again, go check out this book. It's online. It's absolutely free. I always share all my information with you guys because I want you to be learned people. You should have seen it. What's his name? Scott Alan Norick. He's awfully nervous with me in the room. He's flat out telling me, I don't know what you're talking about. I never learned that. I'm really not sure. You have to talk to another judge because I'm not qualified for that. I said, you don't know a whole lot of shit. You don't know a whole lot of nothing. But he knew enough to get me the hell out of that jail. He knew enough that he was in trouble, because even the deputy sheriff said, oh, anybody that talks to Nordic like that normally does 30 days in jail. I ain't doing 30 days. He goes, yeah, that's because you seem to know something. Yeah, I know a lot, Bubba. And then less than 5 minutes later, I'm back at the jail, and the same deputy sheriff is trying to hold me against my will after I've been released. Oh, you got to give me your name, your address, your birth number. I said, I can't give you the birth number. That'd be falsifying a record. I don't have any firsthand perfected knowledge of when I was born. Do you? He goes, yeah, I do. And I said, no, I'll call you a liar. Because you couldn't read a calendar when you come up out of that vagina. Don't you bullshit me. You couldn't read a clock. You were an infant of unsound and unsavory mind. You didn't know a damn thing, son. So you've been told you have a birth date. I ain't dumb enough to lie and falsify a record, and I damn sure ain't going to give you what you need to charge up my estate to pay for you warehousing me, right? So just check it out. Pay attention, ladies and gentlemen. You know, they try to ask me all kinds of things. What's your name? I said, I have a Christian appellation. I don't mind giving you a Christian appellation. My Christian appellation is Derek. That's it. Given to me by the Heavenly Father, bestowed to me upon me by my mother. I've always been known before I was even on this earth as Derek. That's what he calls me. And then when I look up my name and the way it's spelled, it's very, very interesting. Go look up Derrick and look up the definitions for it. One of them is a hangman. And I was like, dear Heavenly Father, if you didn't just bless me and tell me exactly what I'm supposed to do with my life, I don't know what better sign I could come up with. I'm a hangman. I'm supposed to hold the law. I'm supposed to abide by the law, and I'm supposed to hold those accountable who don't follow the law, even if they claim to be lawmen, and really they're lying, looting, pandering pirates under Title 18, subsection 1661, exercising piracy on my land. We can't have it no more, ladies and gentlemen. We got to stand up. We got to stand together. When these lying, looting, pandering pieces of shit get together and try and frame one of us, we need to stand tall, stand proper, stand right, not get agitated and show emotion, but rather smile and know that we're sending your ass to Guantanamo. I'm going to create a song next week. I'm going to put it out there. It should be a #1 hit. On my way to Guantanamo, where I hear the bass real nice. Might make it a country western. I haven't decided yet. I'm going to work on it, though. Love you guys. Talk to you soon.